Okay, so this is Dawson Gage, and I'm making this video at my apartment at 513 Orange Street, Wilmington, North Carolina. And this is a video response, a video answer to this document which I received in the U.S. mail and which I obtained electronically from the Clerk of Superior Court in Orange County, North Carolina. It is composed presumably, I believe, by Professor Beth Posner, who is acting or claims to act as attorney for Elizabeth Kenyon Ross, with whom I'm seeking to reunite after a long separation, notwithstanding the efforts of various others to prevent this just and necessary outcome. In any event, I'd like to respond. I was not able to respond to this in the part of this was the application for an ex parte continuation, an ex parte extension of the Domestic Violence Protective Order, temporary ex parte. This statute, the first thing I'd like to say is that Ms. Posner's use of this statute in this case violates the North Carolina Constitution's prohibition on ex post facto laws. It's an ex post facto, it's a strange case of ex post facto, but it is ex post facto because the statute was amended on the 1st of December 2022, which is to say 3 years after the initiation of the action. So you can't really say that 50B proceedings can have the rules of 50B proceedings altered during the course of the action, because that would basically, it changes the nature of the whole thing. So it's an ex post facto law, and I would point out that therefore the template form, I'd like to know, when did Ms. Posner become aware of this new amendment to Chapter 50B that allowed for this convenient extension of the hearing, and like in the sort of partial holdover, whatever you want to call it, the stopgap, this alteration to the nature of the 50B calendar, which makes it much more easy for the 50B plaintiffs to renew the order. And like in this case, it would not have been this easy. It might not have been possible for Ms. Posner to file this renewal, and for the plaintiff, I'm sad to say, Ms. Ross, to orchestrate this through whatever corrupt and unlawful clandestine communications with various people who she calls friends, who I basically in this point call spies or informants, at least in their current function. What was done in order to prepare for this order was unlawful, and the timing made possible by this ex post facto law is crucial in terms of understanding what this document is. One cannot respond to it without trying to dig under the terms and within the different terms which are used here. I think that, notwithstanding the fact that she has been for many years a professor of law, that Professor Posner is defective in her basic apprehension of legal language, which might be something which can be responded to. But in any event, here's my point. The reasons, or the numbered points which are given in this motion, or this addendum to the motion is on the template form. This is called the addendum. The points here on the, rather than distinguishing between showings of fact and points of law, Professor Posner conjoins fact and law into what she calls reasons, and says that the motion that she moves for the following reasons, among others, to be proven at trial. It's an interesting confusion here, because this has come up before in 50B court in my own case, which is there a distinction between trial and hearing? Is it 50B, is when you get together in 50B court, is that a trial or is it a hearing? The answer is it's not quite clear, because in theory you can demand a jury trial in 50B district court and be tried by a jury of 12. No one has ever heard of it, but in theory it is possible. I think that it has happened, but I've never. Both Tom Wilsby and I had never heard of this happening before. But in theory, you could have a jury trial, in which case it would be a trial, but a judge-decided hearing. This is evident in the confusion implied by the terms on the AOC template form for Chapter 50B, which calls it a complaint and motion. If it's a complaint, then it would be a trial, but if it's a motion, then it would be hearing. If it's a complaint and motion, then it's neither a hearing nor a trial, but the difference being that if Beth Posner is claiming that the anticipated confrontation or whatever, WebEx meeting for which she moves, if this is to be a trial, does that change the nature of the rights afforded and the rules of procedure? So that is my next point. So this said that So with response to point one, this matter was originally filed on October 11, 2019, when an ex parte order was granted by the Honorable Judge Sherry Murrell. I would say that it's important to try to pin down when the original idea of Ms. Ross obtaining a domestic violence protective order. When did that idea? What was the genesis of that thought? Because the history of the 50B orders, when you understand how the different orders connect, it is possible to understand what the intercourse between Ms. Ross and plaintiff in 50B, in the 50B matter in Hanover County, Carter Jewell, and then also Alexa Williams, who when she was my roommate also filed suit against someone under Chapter 50B, and so then there's the oblique relationship to Caitlin O'Hare, 50B plaintiff in Guilford County. So the way, and of course Alexa Williams was the link between Carter and Caitlin. And in fact, Caitlin O'Hare told me personally on the phone when she called me in violation or in defiance of her own 50B domestic violence protective order. In May 2018, she called me on the phone and we talked for about an hour or so. And she told me, among other things, that she had been connected on Facebook to Carter Jewell by Facebook itself, that Facebook had suggested it, and so she took the Facebook suggestion and became Facebook friends with Carter Jewell, which gave Carter the opening to begin to try to influence Caitlin's testimony, which is what Caitlin told me. So the effort of one witness or plaintiff or victim in one 50B case in one county, the efforts of a single. When it's not quite Me Too, is it? If it's two different women, just two in different counties, where one is trying to influence the other. But of course, at that point, Ms. Ross was already in the picture too, and in fact knew that Elizabeth Ross knew Carter Jewell and had met her, I guess in 2016, and in fact Omar Luis Lopez had met Carter Jewell as well. So there's a nexus of connection. Of conspiracy, which connects these different parties, which has not been presented to the court. And in fact, one imagines it would be very, very difficult in order to actually compel or extract this documentary evidence from the parties. In fact, it's quite possible that it has been destroyed. And we cannot necessarily say what was done, but the point being that they themselves know, and there's been a deception and an unlawful obstruction of justice in this matter, and as well, you could describe it as a form of perjury, because in fact, the truth that has been presented in the verified pleadings of the plaintiff witnesses, and also what they said in court, it is clearly missing something which they ought to know is the essence of the thing, which is the ulterior motives and the concealed. There's a certain kind of interconnection and collaboration which is admitted to, but they do so in order to try to make it look benign, or to try to make it look regular, or to try to get away with with saying that this is okay, or to prepare for the Me Too sort of Rule 404B for prior bad acts, sort of collective class action witch trial, which seems to be the idea that has been looming behind all the proceedings to this day. So obviously, of course, in the later reasons given by Professor Posner, she does refer to the other parties, the other plaintiff victim witnesses in the other cases, but only vaguely. And it's here where I raise the question of if the phrase "upon information and belief" is to be used in this case, which I think is of dubious utility. I think in fact it serves to confuse things. But when you say "upon information and belief," and you're a college professor, a university professor of law, and the question, the words information and belief do not mean the same things, because a professor knows that there are other modes of obtaining information, and there might be other, for instance, in her letter to me when I was in jail in Hanover County earlier this year, Professor Posner said that she made reference to what she referred to as my banishment or my trespassing from the UNC campus, from UNC Chapel Hill, and it was clear then I had not mentioned that to her myself, and so one wonders where she found that out, because of course that raises the original question concerning this proper subject matter of these cases and the conflation of different kinds of threat, different kinds of unlawful, fraudulent accusations of threat, which was that originally, when I was arrested at the Carolina Inn, what Lizzie and Omar were saying was that I was a threat to UNC Chapel Hill. So that was before they alleged harassment on their own persons. Although, of course, there was something, in fact, what happened was that Omar Ruiz Lopez threatened me, or at least, said something which was so barbaric and so offensive that it could only be interpreted as a threat. And of course, that was the last thing before he dragged Liz to the law enforcement in Orange County and forced her to say that I was threatening the university. And it really is quite reprehensible and quite troublesome, quite troubling and offensive that this Panamanian space invader was allowed to say that I was threatening UNC Chapel Hill. Although, of course, given everything that has happened since they turned international studies into global studies and they killed Eve Carson, this has been a long series of events which led to the present moment, which shows that this conflict with the university and for the soul of the university is at issue, and fundamentally at issue in North Carolina law and in politics. And it has not been confronted by the people who claim to be liberals or the people who claim to represent the university, academics, higher learning, academic freedom, blah blah blah. So on December 12th, in 2019, upon testimony of the plaintiff, the Honorable Judge Beverly Scarlett entered a 1-year order of protection. So the idea that this could be upon testimony of the plaintiff, I dispute this because I say that the proceedings were coram non judice because I was an officer of the court. I was representing myself. You cannot have a testimony which is not heard by all the officers of the court. If the defendant, we do not have star chamber proceedings in North Carolina, ex parte is provided for in a specific way in Chapter 50B, and it is dubious. It is it's very questionable, as to whether the current ex parte orders are valid at all. The General Assembly says in a clumsy way that they are, but nobody who has to actually live with what an ex parte domestic violence protective order is. If you actually know what it is, then you know that it is deeply unlawful, deeply immoral. It is an offense against nature and an offense against international law to kidnap somebody in the fashion which is made possible by 50B domestic violence protective orders in the ex parte mode. But of course, what the ex parte order does is it weakens you up. And if you concede, once you've had to concede that the ex parte order is real, and in fact, once you've been threatened with the enforcement of the ex parte order, once you've been arrested for the ex parte order, then you have no chance of ever responding adequately to the complaint in motion. And so 50B proceedings in this case, as was, this was at this point, the third 50B order where they had orchestrated the hearing process through unlawful resort to law enforcement during the period immediately prior to the filing of the complaint. And in fact, it was Carter Jewell in both cases. There's an obvious element here where which this female demagogue and democratic feminist white supremacist fascist who ought to have no place in the political life of Wilmington or in North Carolina. Honestly, let's not pretend anymore that this is not a very serious political struggle, and let's not pretend anymore that these fake feminist cheerleaders for this witch hunt, inquisitional lynching, which is being perpetrated against somebody who, honestly, I did not break the law at all. Everybody knows that I'm basically a very decent person who pursues his vocations and who lives here in downtown Wilmington. We don't have to claim more for ourselves than that we have a right. People that are in, I do not have to claim. All I have to say is that this has been a violation of my rights under international law. In North Carolina, if we do not understand that our government has been has gone off the deep end, it has gone into the most. It is unrecognizable, compared to the place that existed when I grew up in the 1990s. It is a different place, and it lives under a different form of government. And this is why I cannot accept Josh Stein as the governor-elect of North Carolina. I do not acknowledge his authority. I do not accept that he has the right to sign bills into law. I do not accept that he has the right to order the National Guard. I do not accept that he has authority to make appointments, and I do not accept that he has the authority to execute the laws of the state. In the meantime, Governor Cooper, I would hope, would exercise his clemency powers and put an end to this nightmare. I will say more about that at a future point. We'll get back to this at some point along the way. Thank you. This has been Dawson Gage, a presentation of Orange Street Law School. Peace.